Шановні колеги,
Dear colleagues, good morning. We are going to start our work in our UCMC and in particular the project to support the communication reform, and we're going to talk about how to stop illegal actions of judicial system against IT business. Last week they had a major meeting in the Ministry of Trade and Commerce, and they discussed the problems and different issues of this business. Not all the problems have been touched upon, and today we invited those people who can tell us what other problems are encountered by the representatives of this business, and I would like to invite them here to this podium. You are welcome. Good morning, dear ladies and gentlemen. Artem Rafaelian, project manager of EasyBusiness, laid the problem of replacing, let's say, the servers in those companies. We came to the surface. I would like to give more information related to this problem and tell you what measures have been taken to avoid or to prevent such situations. How can overcome this complexity or this difficulty further on? Despite the fact that during the last time we witnessed several changes, and if we are talking about the servers in the IT companies of Ukraine, this is not a new problem. About 18 months ago, we came up with initiatives. Actually, it was considered to be one of the top priority of the deregulation this year. On January 15, through the efforts of our companies with the representatives of business, public at large, and the authorities, they adopted the law number 91, which has to resolve the problem of, let's say, seizure of the elements of the IT telecom infrastructure. This law provides further changes in some of the criminal procedural code. In case it is necessary to get some information by the investigation office from the server, it has to be done not by the seizure of the server, but through copying. Seizure can be done only in those cases when the investigation office physically, it is important to have the physical carry of this information, but this can be done only following the court decision with the enumeration of those elements or components which can be seized. Now, we can say that in practice those norms are distorted, and we would like to show you what specific difficulties we encounter today, and my colleague will tell you more what prevents us to implement those rules and regulations and the amendments introduced to the CPC, Criminal and Procedural Code, and what difficulties we meet in our business. Artem Afian, you have the floor. Artem Afian, cooperation partner of the Iuscutum. As we can see, it was very difficult to adopt the law which limits the rights of the investigators to seize the carriers of the information, but unfortunately this law doesn't work. It happened because while coming through different, let's say, coordination procedures, they actually added some kind of the gap through which the court, in a kind of in a blind manner, can give permission to a seizure an area of information. And unfortunately, judicial practice used that opportunity to full measure. Today, the plague associated with the seizure of the elements or components of the IT information actually cover the whole business. And this is not exclusively the problem associated with IT business. Today, the seizure of servers in the same way stops both the IT companies and the transportation companies, logistics company, agribusiness, and the medicine. All of them depend on the information carriers. We are living in the information field era and epoch, and any investigator today can, without any pains of conscience, he has the right to seize any computer or sometimes all the computers. Unfortunately, when the reform of the law enforcement bodies has not been completed, and we have not introduced any regulations regarding the detectives and other structures of the new police, are not in place, maybe with the exception of the traffic police. And this opportunity is being used by those elements of our society who actually are very much disliked by the population. Our negotiations with the representatives of the authorities, some of our complaints in separate cases do not bring fruit. We have no opportunity to bring the minister attention to each seizure because he will spend all his working day to deal with different investigators. I believe we have to return to the legislative work anew, so to say, in order to make strict the requirements regarding the seizure of servers and to prove or to say that if the investigators are interested in the information contained in the server, they can take only information, not the servers. And that's why we would like to propose to expand the sphere of our work and touch upon some accompanying problems. In our realities, the searches became the real threat to business. The searches do not give any, do not improve the quality of the investigation. The searches do not lead to some indictments. And, searches are the tool of terror against business on the part of the really dishonest representatives of the law enforcement bodies. We believe that under such circumstances we have to create some additional legislative barriers against the kind of voluntary seizure of the real tool of our tools of our operation. We believe it's inadmissible. We are talking about the companies who work in the business centers. They should not use special kind of threat teams or special teams of the police, not at least not in the case when there is no threat to the life of an investigator. We have to understand that when an investigator passes a decision on to carry out the search, he has to be sure that there is no other way to get the information he requires. The search must be the ultimate measure to resort to. We have to provide the situation when to prevent those situations, the cases when the people without any grounds are just put on the floor, and when the people for many hours are kept in within the different premises or room, and they do not have the right to call their near and dear. They cannot even visit the toilets when they have a call of nature. But we have to do everything possible to prevent the search to become this kind of tool of violation of the law. We have to bring to the attention of the competent bodies special responsibility of investigators for their actions and to the authorities as well. And today, anything which could actually fill those gaps in our legislation does not work. And then the investigation in many cases has nature kind of self-investigation, and usually if, for example, an investigator doesn't get the permission from one judge for a search, he can go next day to another judge and get this permission for a search. This means that the existing judicial system cannot actually level off and all the or fill the gaps in our judicial practice. So we have to get to make introduction to make some amendments into the judicial practice in order, the CPC, to avoid such opportunity. And otherwise, we will be left without any kind of IT business. So we have a lot of challenges to the economy to leave it without attention. We can visualize the way how to resolve this problem, and actually can shoulder the responsibility, or the, let's say, to undertake the need to draw up the necessary law. And we do believe that this will seriously decrease the tension and threats to the IT business. Now I would like to turn the mic to a representative of business who can tell you how this situation can affect negatively the business in this country, or to prevent it to be spread to other countries as well.
Good morning. I'm Andriy Khvetkevych, the company nic.ua. Probably you have heard that the nic.ua company suffered from expropriation of the equipment, which happened in April this year, and till today we have not received all that equipment, and finally we have made decision that unless we feel ourselves totally secure in Ukraine, we will keep all our equipment abroad. What does it mean for Ukraine? For Ukraine, it means that we will pay money abroad and transfer this money from Ukraine. And that's not only our case. This is the case with many our colleagues and similar companies in the same business sector. Actually, I think this is a very negative trend, and in order to overcome this negative trend, the president and law enforcement agencies should find some solution and stop disturbing and making obstacles for the IT business. I think that IT business is that very sector which attracts a lot of money to the country. And if these companies start to relocate their equipment and even employees abroad, then the country would not receive its incomes. I know one big company which now plans to relocate 500 program IT experts to Poland. Now they spend up to 1 million for the salaries and of those IT specialists, and in case they relocate their business to Poland, we will lose this money. I mean Ukraine. Unfortunately, not all the companies who experienced search and seizure of the equipment during last year, they did not make this public. They simply made quiet decision to relocate to the neighboring countries. Just assume that the IT business interrupts its work here, and in this case the country will lose its revenues, will miss the revenues, and I believe that the authorities are smart enough to understand that the situation should be resolved somehow. Could you explain more specific about the those changes which you suggest to resolve via new provisions? Actually, the problems which you mentioned when you deal with the law enforcement agency about freedoms and damaged rights of people. This is peculiar not just for IT business, for other businesses. So my question, what is the stage of preparation of those changes to legislation? And when you think you will be ready to submit them to the parliament, and which political force you may choose? The problem which we mentioned is rather broad, but we shouldn't introduce very specific changes. The rules in the criminal code dealing with the procedure of the search and the rules in the criminal code which are applied to the seizure of information. And we believe that approximately 1 month later from today, we will be able to present our suggested provisions. Then the legislative authority will need to decide when to register these amendments and when to exit them to the parliament. We are not going to change. No, we are not going to change the principles, the foundations, the procedure of the functioning of the law enforcement agencies based on the criminal code. We understand that that's not the matter now. Artem mentioned that as of today we have already passed the law which has to resolve, had to resolve all these problems. But what we observe that proper application of this new law, it may radically distort all the practice, and that's why we suggest to amend this new law in order to prevent discretional interpretation of this law in the future. Our opponents are not ready to understand the specificities of our work, the specificities of business work, and they tend to use the law provisions to oppress businesses, especially IT business, which contributes 3% of GDP. And we believe that we should force the law enforcement structures to behave in line with legislation and remain within some limits, not making harm to the business. Well, between today and the bright future, which might be improved, definitely will be some period of time, some transition period. How do you think how business may exist within this period of time? What recommendations could you provide to the business for this transition period? I can provide a piece of advice. Business should be ready to insist on its rights and freedoms, because any delayed, any unresolved problems with the law enforcement agencies, it gives birth to further problems to the other companies, and people should demonstrate strong will and enough insistence to protect their rights. They should not fear to irritate the investigator. They should be ready to insist on the enjoyment of their rights. And even the draft law, which we are going to develop, even those draft provisions which we will draft and which will be passed, they would need implementation further, and that implementation will require insistence from people. If you do not fight for your rights and simply pay bribes to the investigator, he will leave you for the moment. He will go temporarily to other company, but then he will come back to you. So businesses remove their websites to the neighboring countries, and now when clients come and say, well, where is your business? Where is your equipment? We say in Warsaw. They say okay, and we now have clients who even request to remove their 1C system, accounting system, to the foreign servers, and because when the 1C software is removed from the company server, with the software is removed from the company gets paralyzed. So my advice is please do not keep quiet and calm, fight. Our project on reform communication is ready to support you. You may participate in discussions and to let people know about your problems. I hope that very soon we will see this document and will be able to create coalition, able to support it. The next